On behalf of the Justice Square Foundation, I am here today to present the findings of a vital report. This report is an exhaustive analysis of the European Court of Human Rights rulings against Turkey in the period following the attempted coup of July 2016. What we have uncovered documents a profound, systematic challenge to fundamental human rights, and in this briefing, we will walk through the key evidence.
We've structured this analysis into 6 parts. We'll begin by setting the context with what we call a chronicle of injustice. Then, we will look at the verdict, told by the numbers themselves. From there, we'll delve into the 3 primary categories of violations the court identified: the assault on liberty, the suppression of free expression, and the fundamental erosion of law. And we will conclude by explaining why this record is so critical for the ongoing pursuit of justice.
You see, in the aftermath of the July 2016 coup attempt, Turkey experienced a wave of unlawful practices. This resulted in tens of thousands of human rights violations. Detentions, arrests, and trials were conducted with such severe irregularities that for many people, seeking justice within Turkey's own legal system simply became an impossibility. This very quote, taken from our reports forward, really gets to the heart of the crisis. When a nation's own legal framework fails to provide protection or remedy for its citizens, the last bastion of hope often lies with international bodies. In this instance, that body was the European Court of Human Rights. To truly grasp the scale of this situation, let's begin with the numbers, because the data from the European Court of Human Rights, well, it paints a stark and undeniable picture. 3,734. That is the number of individuals from Turkey whose cases, all stemming from this post-2016 period, were decided by the court. We must remember that each number represents a human being, a life, a family seeking justice. And out of those cases, 77. This is the total number of violation rulings the court issued against the state of Turkey. 77 distinct instances where the court determined that the state had violated the fundamental rights of its own people under the convention. And what about the cost? Over 16 million euros. That is the total amount in damages the European Court has ordered Turkey to pay to the victims. It's a staggering financial penalty, but it can never truly measure the immeasurable human cost. So now let's turn to our thematic analysis of these rulings. The most frequent, and arguably the most fundamental violation that the court identified concerns the assault on the right to liberty and security of person, a right that is truly the cornerstone of any free and democratic society. Article 5 of the European Convention on Human Rights is absolutely unequivocal. Any deprivation of liberty must be lawful. It must follow a clear procedure prescribed by law. But the court's findings showed this principle was systematically disregarded. You see, the court found repeated and disturbing patterns of abuse. People, including judges and prosecutors who should have had immunity, were arrested without reasonable, convincing evidence. To circumvent that judicial immunity, authorities used an incredibly broad interpretation of being caught in the act, in flagrante delicto, applying it to situations where it was clearly not appropriate. In many other cases, simply having an encrypted messaging app on a phone was deemed sufficient grounds for detention. In its ruling in the case of Alpaslan Altan, a former judge of the Constitutional Court, the ECtHR was explicit. It found this broad interpretation to be not just a legal mistake, but manifestly unreasonable. It was, in effect, a legal maneuver designed to strip members of the judiciary of the very safeguards meant to guarantee their independence, leaving them vulnerable. The second major area of violation our report covers is the deliberate suppression of freedom of expression. The rulings document a systematic effort to silence critical voices, with journalists becoming a primary target of this crackdown. Now, Article 10 of the Convention protects the right to hold and to share opinions and ideas. This is a vital function, especially for the press, in any free society. But the evidence brought before the court showed that the simple act of exercising this right was often treated as a criminal offense. Think about this. The court reviewed cases where journalists were arrested and prosecuted for activities that are absolutely fundamental to their profession: writing articles critical of the government, posting dissenting opinions online, attending peaceful demonstrations, or simply interviewing opposition figures. These are not crimes. They are the hallmarks of a free and functioning press. In the case of the journalist Shine Alpai, the court made a crucial distinction. It stated very clearly that criticism of a government, even harsh criticism, is a protected form of expression.
It cannot, and it should not, be equated with the very grave crime of belonging to a terrorist organization. This dangerous conflation was a key tool used to suppress dissent. And this brings us to our third and perhaps most alarming theme: the erosion of the rule of law itself. The court's rulings indicate that this was not just about individual rights being violated, it was about the very legal system designed to protect those rights beginning to crumble from within. The rule of law is the bedrock principle that no one, not even the state, is above the law. It requires that laws be clear, predictable, and applied equally by an independent judiciary. The cases before the ECtHR revealed a stark and troubling departure from this fundamental principle. A pivotal example of this erosion can be found in how the court handled cases related to the bylock encrypted messaging application. You see, the Turkish authorities had been treating the mere presence of this app on a person's phone as conclusive proof of membership in a terrorist organization. The European Court of Human Rights corrected this fundamental legal error in the landmark case of Agün versus Turkey. The court's ruling was unambiguous. In our digital age, using an encrypted tool to protect your privacy is not, in and of itself, a criminal act. Without actual proof of illegal content or activity, the desire for privacy cannot be the sole justification for taking away someone's liberty. But there was an even more direct assault on the rule of law, and that was the open defiance of Turkey's own highest courts. In several high-profile cases, lower courts simply refused to implement legally binding release orders issued by the Turkish Constitutional Court. The European Court condemned this institutional breakdown in the strongest possible terms. As it noted in the cases of Mehmet Hasan Altan and Şahin Alpay, when a lower court can simply ignore a binding order from the nation's highest court, the entire judicial hierarchy collapses. This act strikes at the very heart of legal certainty and constitutes a profound violation of the rule of law. So, why does this report matter? Why have we taken such care to document these rulings? Well, this is not merely an academic exercise. It is an act of bearing witness, and it's a vital part of the ongoing struggle for justice. We at the Justice Square Foundation prepared this summary for two primary reasons. First, to support the victims in their ongoing legal battles. And second, to create a meticulous, undeniable historical record of these injustices. This report is meant to be a tool in the service of truth, accountability, and the eventual restoration of the rule of law. The findings are clear. The violations have been documented. The verdict from Europe's highest human rights court has been rendered time and time again. We are therefore left with a question that extends far beyond the borders of any single nation. When an international court provides such a clear and consistent verdict, what is the world's responsibility to uphold and defend the rule of law?